Welcome to the IPC's webinar on situation tables. A growing number of government institutions, social service agencies, and health sector professionals are participating in or considering participating in situation tables. When members of a situation table meet, personal information may be shared to help reduce harm, sometimes without the individual's consent. While this may help to ensure safer communities, it comes with risks to personal privacy. The broader the disclosure of personal information, for example, disclosing an individual's name to the entire table, the greater the risk of a privacy breach. As such, all participants must approach the sharing of personal information diligently and with caution. The sharing of personal information must be done in a privacy-protective manner that complies with the Freedom of Information and Protection of Privacy Act, the Municipal Freedom of Information and Protection of Privacy Act, and, in the case of personal health information, the Personal Health Information Protection Act. For the sake of simplicity, I will just use the phrase personal information and the terms situation table member or agency from here on in. Each agency involved in a situation table must have legal authority for its information handling practices, including its decisions to collect, retain, use, or disclose personal information. This is why a privacy-protective information sharing roadmap is essential. If, for any reason, you are considering not using the recommended roadmap, we urge you to pause and conduct a Privacy Impact Assessment, or PIA. A PIA is an organizational risk management tool used to identify the effects of a given process or activity on personal privacy. Guidelines on how to conduct a PIA and a PIA tool are available on our website. But let's get back to the roadmap already developed in collaboration with the Ministry of Community Safety and Correctional Services. The recommended information sharing roadmap begins with a strong governance framework to ensure that all situation table members participate in a privacy-protective manner. A solid framework includes an information sharing agreement signed by the participating agencies. This agreement should confirm who may collect, retain, use, and disclose personal information, under what circumstances, and for what purpose. It also should outline the measures taken to protect personal information. Situation table members also require policies outlining 1. Steps to help ensure that information is accurate and up to date. 2. How individuals can request access to and correction of their information. 3. Rules regarding the secure retention, transfer, and disposal of personal information. 4. Training and auditing procedures. And 5. Transparency requirements. Once you have the necessary governance and planning in place, the first thing to remember is that data minimization is essential to compliance with privacy requirements. At every stage, it is important to ensure that those handling personal information have the legal authority to do so. In short, the collection, retention, use, and disclosure of personal information should be on a need-to-know basis only. This includes ensuring that each situation table member has a legitimate need to know the identifying information before that information is shared with them. However, long before you get to the point of sharing an individual's information at a situation table, remember, it is a best practice to first try and obtain the individual's consent. For example, if a service provider believes an individual, let's call her Jennifer, is at an elevated risk of harm and would benefit from the services of other agencies, it is best to ask Jennifer for her consent to share her personal information at the situation table. In obtaining this consent, Jennifer would need to be informed of what specific information would be shared, which agencies would receive her information, and for what purpose. Jennifer might agree to disclose personal information to some agencies, for example, to health and education agencies, but not to others, for example, to police or children's aid societies. To the extent that disclosure relies on her consent, the restrictions she asks for must be respected. If Jennifer consents to the disclosure of her personal information, the agency that obtained her consent should document the date, scope, and details of her consent. Sometimes, however, it may not be possible to obtain an individual's consent or to obtain sufficient consent. In these circumstances, if the disclosing agency still believes that non-consensual disclosure is required, situation table members will turn to the four-filter approach. Let's say you have a client, Henry, who is not responding to offers of service, but you have reason to believe that he poses a significant risk of serious harm to himself or others. How can you help reduce the risk of harm and still be compliant with Ontario's privacy laws? Let's look at the discussion that must take place before Henry's information may be shared with other agencies. As outlined in the Ministry's Guidance on Information Sharing in Multi-Sectorial Risk Intervention Models, a four-filter approach is recommended for information sharing. This approach is comprised of the following steps. Filter 1, an agency's initial screening process. Filter 2, a de-identified discussion with partner agencies to assess the risk factors. Filter 3, a de-identified discussion to identify who can receive identifying information. And Filter 4, a full discussion among intervening agencies only. During the initial screening process, the agency considering whether to bring Henry's case forward to the table uses relevant personal information it has in its possession to help determine whether Henry is at significant risk of serious harm and if the involvement of other agencies is required. The second step in the four-filter approach requires that the disclosing agency begin by only sharing de-identified information about Henry at the situation table. What is de-identified information? De-identified information is information that has been stripped of Henry's personal information and therefore cannot reasonably be used on its own or in combination with other available information to re-identify him. In some cases, the removal of direct identifiers like name and contact information may not be enough. Unless they are also removed or masked, quasi-identifiers may be used to re-identify Henry. Quasi-identifiers might include information revealing, for example, Henry's gender, postal code, marital status, family information, location, date of previous incidents, diagnosis, ethnic origin, or profession. In each case, you must carefully assess which quasi-identifiers could potentially lead to identifying Henry, while zeroing in on the key risk factors that you will need to discuss in order to mitigate harm. The best way to reduce the risk of re-identification, while ensuring that the table is able to identify and assess cases involving significant risks of serious harm, is to avoid any discussion of irrelevant details and to ensure that relevant details are not discussed in unnecessarily precise terms. For example, it will rarely be necessary to share the individual's precise age or address before Filter 4. Instead, assuming that either of these characteristics is important, at Filters 2 and 3, Irrelevant details can be masked by discussing them in terms of general neighborhood and a relevant age range. For example, minor, under 25, or senior. If, by the end of the Filter 2 discussion, the harm thresholds have been met, the third step is to identify the agencies reasonably believed to be necessary to the planning and implementation of the intervention. Further review of the risk factors in a de-identified question and answer driven discussion will help reveal which agencies need to be involved. For example, if it appears that the risk factors are tied to issues associated with housing and education, it would make sense to consider whether agencies that provide housing, shelter, and educational services should be involved at Filter 4. At this point, identifying information such as the name and address of the individual, may be shared, but only with the identified subgroup of agencies. In other words, only those agencies reasonably believed to be necessary to the planning and implementation of the intervention may remain for the Filter 4 part of the meeting, where they will first learn the identity of the individual. The Filter 4 meeting should be held separately, well out of earshot of the other situation table participants. In addition, the discussion should be limited to the information reasonably believed to be necessary to help plan and implement the intervention. Note that if, during the Filter 4 meeting, individual agency representatives of this subgroup decide to perform a lookup on their respective systems, any further information sharing must also comply with data minimization requirements. Of course, if the initial Filter 4 discussion reveals that another agency should be involved at Filter 4, at this point, that agency can be brought in on the discussion right then and there. During the intervention, consent should drive any further information sharing. This consent should be sought at the first reasonable opportunity. If the individual declines the offer of service, further sharing of personal information should cease. At a later meeting of the situation table, during the report back stage, unless the individual has expressly consented to being identified to the entire group, the report back to the table should be strictly limited to de-identified information that reflects, for example, the individual in case number 1XA was connected with services, declined further service, or that the intervening agencies need to discuss further action. Two more issues bear comment before I wrap up: record keeping and notice. At situation tables, the agency that brings the individual case forward, as well as the planning and intervening agencies, may need to record some information about the case, including some personal information. However, newly assigned, unique, pseudo-anonymous numbers should be used to keep track of individual cases at the situation table, rather than identifying or quasi-identifying information, such as an individual's initials, address, or telephone number. Any other notes captured by any of the other agencies should be securely destroyed, particularly any notes that may contain personal information. As a general rule, individuals should receive written notice that their personal information was disclosed. The notice should include contact information for each agency to whom disclosure was made. Alternatively, the notice could include a contact number or website that would allow an individual to readily access that contact information, as well as ask any other questions. Written notice may be provided by, for example, the lead agency during the first in-person intervention, using a card, letter, or pamphlet. Note that if, at any stage, it becomes evident that the risks are already being mitigated, for example, the individual is already connected to sufficient services, no further information sharing should occur. However, the individual should still receive notice of any disclosure of their personal information from the disclosing agency. Such notice should also reveal the names of the agencies to which disclosure was made and where to obtain further information. The situation table model is an important part of the growing emphasis given to harm reduction in Ontario. Harm reduction is, of course, a laudable goal. At the same time, participating agencies must comply with privacy requirements and be accountable to individuals and the public about their participation in these tables. Situation tables can operate in a privacy-protective manner with sufficient planning and governance. We know this from our experience. The use of the Privacy Protective Information Sharing Roadmap will help you to handle personal information in compliance with privacy legislation. If you are unable to resolve governance and planning issues through your own internal resources, the IPC is available to provide institutions and health information custodians with general guidance on the necessary privacy protective governance framework for your situation table. Thank you very much.